Hello, and welcome to this week's episode of the Illinois Appellate Roundup, where we tackle recent Illinois appellate and Supreme Court decisions that represent important developments in appellate and post conviction law. Today, we'll be addressing three recent rulings from the Illinois Supreme Court, one on the sufficiency of the evidence and the eyewitness identifications behind a murder conviction, one on the crime of solicitation of murder for hire, and one on what it takes to prove your innocence years after a conviction has become final. For each case, I'll give you the holding stated plainly, what the court decided and why, and the takeaway for your own practice. This week is unusual in a useful way. All three of our cases come from the Illinois Supreme Court, and all three were handed down on the very same day. Read together, they are a kind of master class in a single idea, the respect that a court of review owes to the people who actually sat in the courtroom and watched the witnesses testify. Three different doctrines, one quiet through line. Let's get into it. Our first case takes us to a Chicago street on an April evening in 2017. A young man named Tyler and a companion were walking toward a friend's house when someone ran up behind them and opened fire. Tyler was shot 5 times and died. His companion was wounded and survived. The sun was still up, the street was brightly lit, and the only real question in the case was identity: who was the shooter? The state's case rested on eyewitnesses. There were four of them. Two had given firm, definitive statements to investigators, naming the defendant, Antrell Johnson, as the shooter, but at trial, both tried to walk those identifications back. A third witness, watching from a parked car nearby, identified Johnson. A fourth did not. The jury convicted Johnson of the murder of Tyler, but acquitted him of the attempted murder of the companion who survived. On appeal, a divided panel of the First District Appellate Court reversed the murder conviction, concluding that the state had failed to prove Johnson guilty beyond a reasonable doubt. Here is what the Illinois Supreme Court held. It reversed the appellate court, and it identified three separate missteps. First, the appellate majority judged the eyewitness identifications using the wrong yardstick. The test for whether an identification is reliable enough to be admitted into evidence when the question on appeal was sufficiency. The standard asks something much narrower. Viewing the evidence in the light most favorable to the prosecution, could any rational trier of fact have found guilt beyond a reasonable doubt? Second, the majority leaned on social science research about eyewitness memory that was never presented to the jury when a reviewing court is confined to the record made at trial. And third, the majority used the jury's acquittal on the attempted murder count to cast doubt on the identifications behind the murder conviction. But an acquittal on one count cannot be used to undermine the sufficiency of the evidence on another. The Supreme Court reversed and sent the case back. And here is the takeaway. A sufficiency of the evidence challenge is a narrow lane. The reviewing court views everything in the light most favorable to the state. It does not reweigh credibility. It does not import studies the jury never heard. And it does not use an acquittal on one charge to pull apart a conviction on another. If you are arguing the evidence was insufficient, you have to win on the record the jury actually had. Our second case moves us downstate to the Will County Jail. A man named Christian Shepard was being held on serious charges. From inside the jail, he set about trying to arrange the murders of the people involved in his case, the witnesses against him, and the detectives who had investigated him. He approached two fellow inmates and offered each of them money to carry out the killings. Both went to the authorities. One of them, Daniel Robinson, agreed to cooperate and to wear a recording device. On the recordings, Shepard discussed the logistics and the payment, and he signed documents authorizing the use of around $18,000. A jury convicted him of solicitation of murder for hire. On appeal, Shepard argued that the man he had tried to hire, Robinson, was a cooperating informant who never intended to commit any murder, so there was never a real agreement, and the crime could not be complete. Here is what the Illinois Supreme Court held. It rejected that argument and affirmed. Solicitation of murder for hire reaches a one-sided, unilateral arrangement. The offense focuses entirely on what the defendant does, that he, intending that a murder be committed, procures another person by paying or promising to pay for the killing. Whether the person on the receiving end secretly means to go through with it is beside the point. This is different from a conspiracy, which requires a genuine meeting of two minds. It punishes the solicitor's own compensated effort to get someone killed. So it made no difference that Robinson was an informant who never intended to lift a finger. And here is the takeaway. For the crimes that turn on hiring or paying, do not rest a defense on the hired person's lack of intent. The informant who only plays along does not break the offense, because liability lands on the person who pays or promises to pay. Our third case is the oldest, and in some ways, the most human. Back in 1989, a man named Michael McCoy was convicted of a murder committed 3 years earlier during the robbery of a Chicago liquor store. He was sentenced to life. In the decades that followed, he pursued appeal after appeal and petition after petition without success. Eventually, he was granted leave to file a successive post-conviction petition raising a claim of actual innocence. And he was given the fullest kind of hearing our system offers, a third-stage evidentiary hearing with live testimony. His new evidence came from two experts. One was an expert on the unreliability of eyewitness identifications. The other was an expert on a presumptive blood test that police had run years earlier on McCoy's shoes. The circuit court denied relief. The appellate court affirmed, and McCoy carried it to the Supreme Court, arguing the lower courts had failed to weigh the old and the new evidence together. Here is what the Illinois Supreme Court held. It affirmed the denial of relief. To prevail on a claim of actual innocence, the new evidence must be conclusive, so strong that it would probably change the result on retrial. McCoy's evidence did not clear that bar. The expert on eyewitness reliability was, in substance, impeachment evidence, an attack on the credibility of identifications. The jury had already heard tested on cross-examination, and impeachment evidence is rarely enough to justify post-conviction relief. The eyewitnesses had stood just a few feet away in a well-lit store, had seen the shooter on earlier occasions, and had given consistent, credible accounts. The blood test expert merely confirmed what the state's own officer had already told the jury, that the test was preliminary and could not even establish that the substance was human blood. None of it, the court held, was conclusive, and here is the takeaway. Actual innocence claims live and die on the conclusive character element. A freestanding expert attacking the reliability of eyewitness identification will usually be treated as impeachment, not as new evidence of innocence, especially where those identifications were already tested in front of the jury. You need evidence that affirmatively points somewhere else, to another person, to a fact that cannot be squared with guilt. So here is the thread that ties this week together. These are three very different cases: a sufficiency challenge, a question of statutory interpretation, and an actual innocence petition. But underneath, they are all about the same thing: respect for what happened at the trial. In Johnson, a court of review cannot reweigh the evidence, reach outside the record, or second-guess a jury's split verdict. In Shepard, the statute means what it plainly says, and a paid solicitation is complete the moment the defendant pays. And in McCoy, even decades later, undoing a conviction takes evidence that is genuinely conclusive. The trial is where the witnesses are seen and weighed and judged, and our courts are slow and careful about disturbing what was decided there. That is your roundup for the week, and every case is real, recent, and published, so you can read each one for yourself. Thank you for watching this week's episode of the Illinois Appellate Roundup. If you are in need of appellate or post-conviction representation, please do not hesitate to call me directly at 312-5-173-877. I'll see you next week.